First case before the court, State of Ohio versus Michael McKee, is 26 CR 253. There are 5 counts. 4 counts of aggravated murder, unclassified felonies, and 1 count of aggravated burglary, felony 1. Each of these counts come with a 3 and a 6-year firearm specification.
Thank you. Counsel, please make your appearance.
Thank you, Your Honor. Diane Menashe on behalf of Michael McKee.
Thank you.
Your Honor, with respect to the allegations, we would acknowledge receipt, waive reading, enter not guilty pleas to all counts contained therein.
Michael McKee, the man accused of killing a dentist and his wife, was back in court, this time in the state where he is charged with their murders. And it has been announced that he has hired a very high-profile, high-powered attorney, Diane Menashe, somebody we have spoken to before here on Law and Crime. What do we know about her? But more importantly, are there any clues from her past successful cases that can give us clues as to how she might defend this guy? Let's talk about it. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. They were a successful, beloved couple. A dentist and his wife found shot to death in their own home in the first light of the new year. And for weeks, the question became, who? Who could have done this? And that is when the spotlight turned to the ex-husband. The ex-husband of the wife, a Chicago surgeon named Michael McKee. There was a manhunt, there was an arrest, there was an extradition, and now he's here sitting in the Franklin County Jail. His first Ohio court appearance happened today. We're going to play a little bit of it as well, but really what we want to focus on this sidebar is something different, because this case took a turn into very familiar territory for us here at Law and Crime. Why? Because he hired a lawyer that we know very well. It is a name that you've heard before on this show. Diane Menashe, a 27-year veteran who has covered a lot of big cases. In fact, she's been with us here right on Sidebar. Let me bring in Diane Menashe. She is a trial attorney in Ohio. Diane, so good to see you. It's been a minute since we have a chance to talk. Unfortunately, these are the circumstances. Before we even get into all of the legal components of it, what is just your overall reaction when you heard about this? Because this is from your home state. See, we know her. I wasn't lying. Now, Menashe is a very high-profile defense attorney you call on when the stakes are life and death. She has fought in some of the biggest murder trials that we've seen recently. So as I mentioned, 27-year veteran. Okay, she filed an official notice of appearance in this case on January 22nd. She has defended about 36 people that have been facing the death penalty. Again, very high-profile cases in Franklin County. She's also somebody who is apparently opposed to the death penalty. To give you an idea of who we're talking about, by the way, she grew up in Seattle. She attended Purdue University. She got her law degree at Tulane University in New Orleans. She worked in the Ohio Public Defender's Death Penalty Unit. She's actually an instructor in Harvard Law School's Trial Advocacy Workshop. She's a fellow in the American College of Trial Lawyers, the International Academy of Trial Lawyers. She is very, very accomplished. And in fact, we have covered cases before where she was representing the defendant in very high-profile cases. I mean, do we remember the cases of former Mount Carmel Dr. William Husel? How about Matthew Moore? And now she is building the defense for Michael McKee. So the question is there anything from those past cases, her tactics, the way she fought those, that will give us an idea, a clue, as to how she might defend Michael McKee? So as we ask what fight are we about to see, because with Diane Menashe on board, it's not just about what happened that night. It is about how every single piece of evidence is presumably going to be challenged, how the police investigated this from the start. Because remember, the defense doesn't have to prove that Michael McKee didn't do this. Their job is to raise reasonable doubt. Their job is to say the prosecution cannot meet their burden. They can't dot all the I's, they can't cross all the T's. Now, before I break down what we've seen from Diane Menashe, Michael McKee, he did appear in court earlier today for his arraignment. And through his new attorney, Diane Menashe, he was read the formal charges and he pleaded not guilty. Here's what went down with this crucial first legal showdown.
First case before the court, State of Ohio versus Michael McKee, is 26 CR 253. There are 5 counts. 4 counts of aggravated murder, unclassified felonies, and 1 count of aggravated burglary, felony 1. Each of these counts come with a 3 and a 6-year firearm specification.
Thank you. Counsel, please make your appearance.
Thank you, Your Honor. Diane Menashe on behalf of Michael McKee.
Thank you.
Your Honor, with respect to the allegations, we would acknowledge receipt, waive reading, enter not guilty pleas to all counts contained therein. We would also waive bond at this time, although we certainly reserve the right to raise that at a later date. The plea of not guilty form has been executed and signed on behalf of my client. Nothing further.
Thank you, counsel. I've signed the not guilty plea. I'm signing the bond form indicating that bond has been waived. Anything further?
No, Your Honor.
Thank you.
Thank you, Judge.
Thank you.
Okay, so now let's get back to Diane Menashe, the driver of the defense's side. So what are we expecting in terms of strategy? I want to briefly reset the table to look at the details that Menashe is going to be attempting to chip away at in this case. So let's start there. Michael McKee. He's accused of entering the home of his ex-wife, Monique Tepe, and her husband, Spencer Tepe, in the early hours of December 30th, where prosecutors allege he shot and he killed both of them. The charges, 4 counts of aggravated murder. We're going to break it down. 2 for allegedly killing with prior calculation and design, talking about premeditation, and 2 for allegedly killing while committing an aggravated burglary. It's kind of like a felony murder rule, so 2 different theories to get him on the hook. There's also a major specification in this case that a silencer, a suppressor, was used. Now, to be clear, if the allegations are true, this wasn't a random act of violence. Michael McKee and Monique Tepe had a past. They met and married in August of 2015. The marriage was short-lived. By March of 2016, just 7 months later, Monique had filed for divorce. But the court filings cite incompatibility. And at the time, McKee was finishing his medical residency in Virginia. The divorce was finalized. Monique moved on, eventually marrying Spencer Tepe, and they were approaching their 5-year anniversary. And by all accounts, again, the divorce didn't seem to be very hostile, didn't seem to be filled with animosity, which makes the allegations just even more confusing and chilling. But for years, they apparently led separate lives. McKee building his career as a surgeon in Chicago, the Tepes building their livelihood in Columbus, and on the surface, it was a clean break, years in the past. But prosecutors are now alleging that history formed the motive for a premeditated, calculated attack. This all brings us back to Diane Menashe. If we look at her past high-profile defenses, we can maybe see how she'll likely approach this case. So for example, 2023, Diane Menashe defended Rodney Vannatta, who was accused of murdering his own wife, Heidi Duda, in their car. And the prosecution had a circumstantial case. They were together. He was the only one there. He made the 911 phone call. But you know what Menashe did? Menashe's defense was built on 2 powerful pillars. First, there was an alternative theory of the crime. So she pointed to another man, someone the victim had a relationship with, who had a violent past. And second, she relentlessly accused police of tunnel vision, of locking onto Vannatta from the start and failing to investigate anybody else. And you know what? The jury acquitted him in just hours. Now, maybe difficult in this case from what we've seen, right? There doesn't appear to be any alternative suspects. There doesn't appear to be anybody else that would have had a grudge or animosity towards the Tepes. And if you couple that with what we've seen so far from the prosecution, right? So there's been evidence that they have tracked McKee's car from being in that area all the way back to the other side in Illinois. The idea that they found a weapon that was potentially linked to the homicides. We don't know what other digital evidence they have, forensic evidence they may have. But that's what could be challenging about an alternative theory. Now, could she possibly argue tunnel vision? Maybe, but we'll see where it goes. This brings us to the case that I would say arguably made her a household name in legal circles. It was the defense of Dr. William Husel. Now here, the state had charged him with 14 counts of murder, alleging he intentionally overdosed ICU patients. And Menashe and the defense team, they focused entirely on causation and reasonable doubt. So they argued that the patients died of their catastrophic illnesses, not the medication. Their entire case was about redirecting the story away from intent and toward complex medical uncertainty.
I want to talk about turning now to patient James Allen. Again, State's Exhibit 30 of your report. Tell me if there's ever anything that you need to look at, by the way.
This is a patient we already covered as well?
You know what, it's sometimes it happens, sometimes it doesn't, but I'm not covering territory that I already have. So I just want to go here with respect to your mention of DNR-CC. You would agree with me that in terms of code status, DNR-CCA means do not resuscitate, comfort care, arrest, correct?
Yeah, I don't use those terms CCA and CC. That's pretty specific to this hospital.
Okay. So then based on your review and work on behalf of the state of Ohio, did you come to know that within the hospital system, CCA meant comfort care arrest?
Yes, I did.
And did you also then learn, through your work with the state of Ohio, that CC means comfort care?
Yes.
Yet I just note in your report, and DNRCC is not something you use at Vanderbilt?
Correct.
Because I note in your report that you indicate that the goal of DNRCC is symptom management for best quality of life. Do you see how you write that?
Yes.
And fair to say, you write that almost in every patient's review, do you not?
Yes.
Something you kind of repeatedly state.
That's right.
And putting aside what codes you use at Vanderbilt or what codes you might know other hospitals use, Mount Carmel West, when you saw CC, it meant comfort care.
That's right.
Also, I want to talk to you about this sentence right here, where you said that Mr. Allen remains stable in the ICU, and his body accepted the treatment provided up until his death. Did you see that, number 7?
Yes, I did.
Okay. We have, as you I'm sure recall because you reviewed his medical records, Mr. Allen had 4 organs that were shutting down on him, correct?
That's right.
He was on vasopressors, correct?
Right.
He's on a ventilator.
Yep.
And your conclusion with respect to 7 was that he was stable.
Well, I was referring, you want me to explain what I meant by that?
Well, I'll lead with yes or no. Yes or no with respect to number 7, you indicated, did you not, Mr. Allen remained stable in the ICU and his body accepted the treatment provided up until his death. That's what
yes.
Okay. And then I want to go down here where you indicate there is no clinical basis to remove Mr. Allen's breathing tube. Do you see that sentence?
Yes.
You would agree with me that separate from one another are indication and consent.
Yes.
Indication is on the physician side. Consent is on the durable power of attorney kin side.
Right.
Putting aside indication, if the family, next of kin, durable power of attorney, makes the decision to palliatively extubate an individual,
Yes.
that's what has to happen.
Yeah, I agree. And I disagree with the sentence that I wrote.
Now, there may be some difficulty here because I don't know if there's going to be a dispute as to what happened to the Tepes. I mean, it seems to be clear that they were killed in their house, right? This is not a dispute about cause of death. It does become a question about adding the pieces together, right? So with regards to McKee, perhaps Diane Menashe's defense will try to shift the focus. Could the forensic evidence have another explanation? You know, that's something to take into account. Yes, you know, investigators say we have the evidence of the car, maybe have evidence of this, we have evidence of that, but it is going to be questioning those experts to determine, was there another DNA sample? Are we 100% sure the ballistics match up? How do you know that was McKee's car? Maybe it was a car that a lot of people had. So these are going to be ways to strike at the actual digital, technological, forensic, ballistics evidence. Could there be other possibilities? And the idea here is to make the jury question the origin of the entire narrative, as she did successfully here.
Relative to count 11, we, the jury in this case being duly impaneled and sworn, find the defendant not guilty as to count 11 of the indictment for murder and not guilty of any lesser offense, signed by each and every juror. This is the 20th day of April, 2022. The 12 signatures are present, along with the 4-person designation.
Okay, so now let me tell you about another case. Matthew Moore. This was a big one. And I will tell you, it was a tragic story. We actually covered it on Prime Crime, my other show as well. But May of 2020, a woman named Emily Noble was reported missing from her home in Westerville. She was a forager, someone who loved nature, and then 4 months later, in September, her remains were found in a wooded area near her home. She was in a kneeling position, she had a USB cord tied around her neck, there was a water bottle nearby, and her husband, Matthew Moore, was the one who reported her missing. There was no confession, there was no eyewitnesses, there was no direct physical evidence like blood or DNA tying him to the scene. So you talk about Diane Menashe for a second, right? As of right now, are there eyewitnesses to what McKee is accused of doing? If he's been silent. Since he's been picked up, maybe no confession. What about the physical evidence? Again, we haven't heard a ton about forensic evidence yet. But the prosecution's case, going back to Moore, it hinged on a theory that he had killed her and then staged the scene to make it look like she did something to herself. That was the heart of the case the jury had to decide. Obviously, we're dealing with a different situation here. Maybe, unless Diane Menashe, I have no evidence to say this whatsoever, this is purely speculation, unless she would maybe say that the scene is not what it appears to be, that perhaps it was a case of homicide and self-harm. But again, that could be a stretch. There's no evidence to suggest that is where they're going. So, but going back to this case, here it became the alternative. Was it a homicide or a tragic alternative by a woman who had apparently suffered profound trauma, including the tragic loss of her stepson just months before? So two theories here. And this was a case, the Moore case, that was built on forensic interpretation. And Diane Menashe defended Matthew Moore, okay? Menashe's defense was built on creating a plausible alternative to the murder, focusing on experts who testified that the injuries could be consistent with Noble being responsible for her own death. And she highlighted Emily's history of trauma, her known habit of going into those very woods. She argued the police had tunnel vision, again, focusing only on the husband from the start. And you can hear her entire strategy in her opening statement.
We also expect Dr. Smock will explain to you that based on the scene, based on the injuries, based on his opinion, this was a staged suicide, something that made to look like a suicide. Again, if you read the end of that book and saw the pictures and saw Miss Noble the way she was, you may think one thing. But when you get a chance to hear about the characters and see the timeline of events and see the injuries and hear all this testimony, the ending is not what it seemed maybe at first glance, but it's far more complicated and far more real than that. Now, ladies and gentlemen, we expect that what you'll hear during the testimony as well is that Mr. Moore, from the beginning, was trying to control the situation. That he continued to stage this scene other than the physical scene that you saw or that you'll see occurred in those woods. And we expect that you'll hear during the testimony that Mr. Moore, the night of the 24th, going into the early morning of the 25th, that very important time frame in this case, that between 1 and 4 in the morning, he's sending messages to friends, stating he's taking a sleeping pill and that's probably going to sleep in. Again, I believe the evidence will demonstrate that from the beginning, Mr. Moore is controlling the scene and trying to stage what eventually will be located in those woods. That becomes of paramount importance when we believe you'll hear testimony today of Mr. Moore and comparing Mr. Moore's original statements to law enforcement about when he woke up, roughly 10 or 11 a.m., and that's inconsistent with some of the activity that occurred on his phone, demonstrating that he was awake far earlier than that, about 8:30 in the morning, and that he was awake even further in the earlier morning up until about 4 in the morning. So we expect that when you hear the testimony that there's a major discrepancy in the time frame. You'll hear part of that today when you hear the initial statements, as well as when looking at the cell phone forensics. Ladies and gentlemen, we expect you'll find out during the testimony that that's not all. That the defendant sent a text message to Emily just before noon on the 25th. Used the Find My iPhone app, which is an application designed to try to find where someone else's phone may be. And that he did that in around noon hour on the 25th, instead of leaving the room that he was laying in, instead of walking through the house to see if Miss Noble was there. And again, we expect you to hear testimony that it wasn't for at least 6 hours after that before Mr. Moore finally called someone and said, "My wife is missing." Ladies and gentlemen, you'll see body camera footage from Officer Hollis today. Again, Officer Hollis is the responding officer on the scene. He came, had the initial conversations with Matthew Moore. And we expect that you'll see during that body camera footage that there's a specific area noted in the back of the garage that after some period of time, almost 2 hours after the report, Mr. Moore points to and says, "This is weird. This cord doesn't belong here." And what we expect you'll see during the body camera footage is that there have been things moved during the pendency of when Officer Hollis originally first comes on scene to when the defendant points this area out. Following that conversation and during that conversation, you'll hear that Mr. Moore says, "This area is weird. I haven't touched it, but this seems out of place to me. Somebody must have done this." But what we expect you'll hear is that this is just another example of the defendant controlling the scene, staging the scene to make this look like something other than what it was. Now, ladies and gentlemen, after 2 weeks of testimony, you're going to hear evidence about cell phones, physical evidence. You're going to hear about the parties, everyone involved. And we ask you to be diligent in your review. Diligent in your review of the timeline, how things go together, and diligent when reviewing this case and discussing. And at the end of the 2 weeks, we're going to ask you to see this for exactly what this is. And we're going to ask you to make a finding of guilty of the charge of murder. Thank you.
As I introduced myself yesterday, Diane Menashe on behalf of Matt Moore, my co-counsel, Alexander Petrillo. The state, I just listened to them for about 30 minutes, and they told you their theory. Their theory is that Matt Moore killed his wife. Don't know when, but Matt Moore kills his wife, and then somehow gets her body into the wooded area where you walked yesterday and stages her death. And then I heard the state go on to say that their evidence will show how not just was he that sophisticated to figure out those two things, but he then also took great efforts to control the situation after May 24th and May 25th of 2020. Members of the jury, the evidence will show that the state's theory is based on speculation and inferences. It is not supported by the evidence. And simply, members of the jury, their theory doesn't make sense. Now, I know you were listening to the state's opening just as well as I was, and the judge has already told you that our opening statements are not evidence. They are just how we believe the evidence will unfold. But I say this, that in my 30-some minutes of listening to the state's argument, I noted that they didn't mention reasonable doubt. That is their burden. Their burden is proof beyond a reasonable doubt. And we talked about that in voir dire. It's their burden and their burden alone. And the judge has already given you the instructions of law, and he will again, which say, if the state fails to meet their burden, then the only appropriate verdict as to each of the 3 counts in this case is not guilty. And here's why I mentioned reasonable doubt, and that they didn't mention it, is because as the judge has told you, and as I talked about in voir dire, reasonable doubt is a doubt based on reason and common sense. And so I want to talk about this morning during my opening statement as to why it doesn't make sense that Matthew Moore, and I'll call him Matt, that Matt killed his wife Emily and then staged her suicide. First, members of the jury, the evidence will show there's no physical evidence. You will hear evidence the state will put on, we anticipate, that law enforcement extensively searched the area of 46 Abbey Cross. Not just Westerville Police Departments, but the Ohio Bureau of Criminal Investigations was brought in. A unit whose sole job, members of the jury, is to look for forensics. They're there too. And it's not just the house. And when I say the house, members of the jury, the evidence will show that they searched the entire perimeter area. But the evidence will also show that exhaustively and extensively they searched the Ultima, They searched the Subaru. They searched the attic with Matt's permission, by the way. Did they do all these searches? They searched the bedding, the sheets that were in Joey's bedroom, where Matt Moore told the police the evidence will show he slept. Members of the jury, there's also no evidence of staging. I certainly listened to the state's opening that their theory is that Matt kills her, takes her to the wooded area, and then stages her death. And this is why, as you listen to this evidence, I ask you, members of the jury, to really use your common sense. Because the evidence will show that Emily is found in the position where you stood yesterday, under that branch. She's found with her water bottle next to her. Her hair is down. We know that because the way her hair is matted when she's found. Her hair is down. Hair tie around her wrist. She's in her walking clothes. And hair tie around her wrist, I just say, is because we know that the last person that saw her leaving for a walk. She's in clothing that, as you look closely, right, is clothing that you would wear when you're walking. And you don't even need to look closely because the evidence will show she has her tennis shoes on. Not the shoes or the clothing that she's seen in the night before. And the evidence will show there is no question as to what Matt and Emily were wearing on the night of the 24th, on her birthday, because we have pictures, selfies, that they took of themselves at the bar as they're celebrating her birthday.
And guess what happened? Matthew Moore was acquitted by a Delaware County jury on August 26, 2022 for the murder of his wife, Emily Noble. You know, it was notable because the judge in that case, Greene County Judge Stephen A. Wolves, had said that while everybody was looking for justice for Emily Noble, he says, I think the jury also said that justice for Emily is not injustice for you. And they reaffirmed that. And so that was also a case built upon alternative theories. There was an argument that the investigation was a bit sloppy, that they didn't properly secure the scene. Those are the bread and butter of defense attorneys. You question every aspect of an investigation. And if there's any part that doesn't appear to be 100% reliable, that is room for reasonable doubt. Now, what will we see in the Michael McKee case if it eventually goes to trial? I don't know. But this is kind of a preview of Diane Menashe, what she's done in the past. She has a successful track record in high-profile cases. We shall see. And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. We're also on NBC's Peacock as well. Hopefully you can check us out there too. If you want to follow me, X, Instagram, I got my News Nation show, Jesse Weber Live. I hope you can check that out too. I'll catch you next time, everybody.